and welcome to The What Show, a show where we dissect the ins and outs of social, economic, business and money matters of Malaysia and Southeast Asia. I am your host, Behans, and today I have something that concerns you if you are a salary worker just like me. The big scary word of the day is retrenchment and also employee rights. So, data from the Department of Statistics Malaysia revealed that the unemployment rate fell from 4.7% in July, from 4.9% in June, and 5.3% in May. The number of unemployed persons in July stood at 745,000, a decline of 28,200 people compared to previous months. So, big numbers aside, the COVID-19 pandemic has taken its toll on our economy, and that in turn led to many Malaysians losing their jobs. Be it retrenchment, layoffs, VSS, MSS, we dive deep on what your rights are as an employee if you are given the boot. So with me here today is Aneera Chowdhury from the legal practice AJ Chowdhury. Aneera handles both litigious matters such as industrial relation disputes, non-litigious matters such as employment advisory work in relation to dismissals, termination, retrenchments, and foreign workers. Hi Aneera, I'm so glad you're here today. So how are you doing?
I'm fine, thank you. How are you?
I'm doing great. Okay, so we'll dive straight into the questions. And first question for 1,000 points. Can my boss fire or retrench me citing bad business performance or slow market conditions?
Well, the answer is half yes, half no.
Okay, why do you say that?
I say that because if there is a genuine retrenchment or redundancy situation in the company, which leads the company to think that it needs to reorganize, and for business purposes, it's a genuine, authentic need to reorganize, then yes, your employer may have some grounds to find certain roles within the company redundant. And if such roles are redundant, then the employer can undertake a retrenchment exercise. Now, of course, the employer can never do that willy-nilly. Okay. It can't be arbitrary. It can't be based on improper motives. It always has to be for good business reason. And the employer, which is the company, always has to follow all the principles and laws on retrenchment.
So when you say justifiable manner with reason, what are the reasons they can justify this termination or retrenchment? Right.
So if we're talking specifically about retrenchment in Malaysia, then what the employer must be able to show is that the role no longer exists within that category of employees. For example, in times of COVID, certain companies' sales have gone down of their products. Companies are just not selling as much. So if they're not selling as much, then do they need, let's say, 50 people in their sales workforce, in their sales team? So if they can justify the fact that they no longer need 50 people in their sales team, then they can say, okay, fine, how many do we need? And if we need less, then let's work towards retrenching the ones that we don't need. But they must always follow the law. And the law states that number one, you must show that there's a genuine need to do the retrenchment.
So I have to show them my P&L or?
Generally, if it goes to court, if it's in industrial court, the industrial court will have to see the company's accounts, the P&L, and you have to justify your numbers. And then number two is that the employer has to apply a selection criteria in the employees that it wants to keep and it doesn't want to keep. It doesn't mean that, I like this sales guy better.
You buy.
No, not at all. It doesn't work that way because you have to be fair to your employees, which means that you have to apply a good selection criteria, the most basic of which is that you have to follow the LIFO principle. The LIFO principle is last in, first out.
Okay, last in, first out.
Yeah, which means that the most junior person in that role or in that category of employee, so your junior most salesman, has to be retrenched first. Right? So even though you like him or her the best, That doesn't mean that you can keep her. If you're undertaking a genuine retrenchment exercise, you then have to apply LIFO and then start cutting out the junior ones first.
Okay.
Yeah.
So, based on your experience, could you share with us some of
Sure.
what you've seen so far in the past couple of months in terms of how employers conduct these kind of retrenchment layoffs, or
Sure.
do they need to consult you, or I can just say, okay, let's you bye.
Right. Well, I mean, I always recommend that my clients consult me
Okay.
for legal advice because it's quite a complicated process to undergo. And there are a lot of things that the employer has to think about, like they have to notify SOCSO, they have
Okay.
to notify EPF, they have to notify tax people, they have to notify the labor department. Whenever they undergo a pay cut process, or they offer VSS, which is a voluntary separation scheme,
Yes.
or they retrench people, you have to let the labor department know. So those are done in forms known as the PK forms.
Okay.
And there are a lot of things that the employee needs to think about, such as how much notice should I give my employees, termination benefits payable, should I undergo a mutual separation first? Maybe we can have a discussion with them, give them a choice, mutually separate, as opposed to doing a one-sided retrenchment exercise. Should I have town hall? Should I be transparent? Should I disclose my numbers? That sort of thing. So generally, when for my clients who are the employers,
Okay.
I ask them to be as transparent as possible with their employees and explain the situation as much. And I also say that it's better if you try and take steps to save, or rather, it's better to take steps to avoid retrenchment if
So
possible.
that should be the last worst case scenario.
Exactly.
Retrenchment.
Yeah.
Okay. So what are some of any examples you can share?
Right. So of course, during this MCO time, it was a lot of people have lost their jobs.
Yep.
And I think that most of the retrenchment exercises that have been undertaken throughout Malaysia have been legal and necessary in order for businesses to try and survive. If the business survives, then it is able to employ the people that it needs, which means that it manages to keep the jobs that are there. But at the same time, it's a very difficult situation for other employees. And also, I can't talk about my ongoing matters, but there are employers, of course, who will say, well, maybe now's the time we can do some cleaning up.
Yeah.
So that's not quite legal, because it then goes against the principle of retrenchment, which is that it has to be a genuine business need to retrench. So if the employer then takes the opportunity or kind of uses COVID-19 as an excuse to retrench, then that may not be legal, and that can be challenged in court.
Okay. So the problem now is, how do they then, going back to my earlier question, they're trying to justify, so then they'll cook the books, and we don't talk about that here. We're not endorsing anything, but these are the scenarios that could happen in a business somewhere within our borders.
It could happen, yes.
It could happen.
Yeah.
So aside from a genuine business decision to drop in sales, what are the other grounds of legal or lawful termination of services?
Okay. In Malaysia, there's only 3 lawful grounds for termination of one's employment, and the first one is retrenchment.
Okay.
The second one would be on grounds of poor performance. If you have a poorly performing employee, you can exit them on grounds of poor performance, but that's a whole other process to follow.
Okay.
You have to warn the employee, or give notice to that poorly performing employee, saying that, hey, you're not meeting the mark.
Yep.
I'm going to give you time to meet the mark. Okay. Usually that is then done by way of a PIP, which is a performance improvement plan.
Okay.
So let's take the sales example again, the sales team example. If you have a bad sales employee and that employee is not meeting his sales figures, and then you have that chat with him and you go, you're not meeting your sales figures, your KPIs or whatnot, I need to now put you on an improvement plan. You must then impose reasonable targets, reasonable time to improve on the employee, give them as much guidance as you can, and if at the end of that the employee is still not performing, then you can move on to terminate employment. But if there's improvement, then you can't. But then your objective would have been reached, which is that you now have a better employee than you had before.
Using that sales example again, let's say my target for that particular, I'm an employer, that employee's target is 20,000 of sales of in a month. And then, okay, let's deliberate. We know he's probably reaching about 5,000 ringgit in sales target every month. So I'm thinking, okay, I want to kick him out. So do I then raise the bar to 25,000 or 30,000, knowing well he's not going to achieve it? So he falls into my trap.
Right.
Yeah.
So I would argue that that's wrong, obviously, because you've made it unreasonable and impossible for the employee to reach his target.
Okay.
And we then go back to rule number 1. So in Malaysia, the law is very pro-employee. And if a case ever goes to industrial court for unlawful termination of employment, the industrial court is not bound by very strict rules of evidence and like other court requirements. What the industrial court does is it is a court of equity and justice.
Okay.
And that means that the industrial court will look at each case and decide on the facts of each case whether the employee has been unlawfully treated or unfairly treated. The employee, your sales employee who's just been given the $25,000 target, if the employee can show that, hey, you know, the other employees don't have the same target, you just did that because you wanted me out, and if the industrial court sees that there is evidence of that, then the industrial court will immediately find this is an unfair labor practice and would find that the employee has been victimized, which usually leads to a judgment in the employee's favor.
Okay.
Yeah.
So let's say I am that salesperson. I have been unlawfully terminated. My boss gave me that 25,000 ringgit target. So who can I turn to? Typically, people will say, "Oh, you go to labor law, labor office."
Right.
But what does it mean? How do I prepare for that step?
Okay. When I tell my clients who are employees, because I advise both sides, I have clients who are the companies and I have clients who are the employees. And I like it when my clients who are the employees approach me when they are still in employ, but they feel that there's something going on in the workplace.
So it's not before I get my termination letter?
I mean, it can be before, it can be after, you know, but I find that employees actually have very good instincts when they realize something's about to happen. So as soon as you feel that something is wrong, or that you're about to have to undergo some kind of poor performance process or disciplinary process or whatever it is best that, you know, you don't have to see a lawyer, but it's best that you start reading up on what your rights are. Because in Malaysia, even though it's pro-employee, there are very strict deadlines involved. If you want to go to industrial court, you have 60 days from date of termination. If you want to claim constructive dismissal, time is of the essence. If your employer is forcing you to resign, time again is of the essence. You can't sit on it. If your employer is trying to transfer you somewhere and you feel that it is prejudicial to you, you can't allow yourself to be transferred and then seek legal advice later, you know, because it seems like you're kind of condoning it. So timing is very important, and I think that employees in Malaysia need to be more aware of the fact that time plays a part in how they then respond to what their employers do to them.
Okay. And typically, let's say from the moment I see you, for example, I'm still the employee, how long does it take before I get my final verdict or results after going through all the process?
Right. Okay. So remember when I said that there were 3 reasons to terminate employment lawfully: retrenchment, poor performance. So for poor performance, then you need to undergo that whole process. So it really depends on how long your employer wants you to undergo a performance improvement process. The third reason is if the employer finds that you've committed some kind of misconduct.
Okay.
Which, let's say you steal money from the till.
Yes.
Right? So that is quite a serious crime. It's dishonest, it's theft. And the employer then will be able to summarily dismiss you depending on how seriously the employer views it. So in that sense, you might be sacked immediately, all right, or you might be given 24 hours notice or all of that. So timelines, there's not really how long you should wait. But if, for example, the employee feels that they are being targeted, the employee actually has not done anything wrong, but the employer is now making unfounded accusations. So that's the point where you need to start reading and need to start protecting your rights a bit more, perhaps by protesting the whole process, the disciplinary action being taken against you. That's when you need to act again. You don't wait until, if possible, don't wait until your employment is terminated before you take action.
Okay. What are your thoughts on the market right now? Are employers taking advantage, or they are really concerned about the business and they are doing it in good faith?
It's difficult to answer that. I think that certain industries, anyone can see that they're in trouble. Oil and gas has been in trouble for a while. There's now the aviation industry, the airlines industry. So I don't think anyone can dispute that certain businesses are definitely in trouble. And then that's when those businesses have to strike a balance between keeping the business alive, keeping their business as healthy as possible, or cutting their losses, but also taking care of the employees. It's not an easy job to do, and you are going to hear sad stories because people are losing their jobs during this time. But I don't think that I don't think it would be right for me to say that a lot of businesses are taking advantage to try and get rid of employees, mostly because employers mostly know that in Malaysia the law is very pro-employee, and if they take one wrong step here or do something wrong over there, they know that it could land them in industrial court. Right? And in industrial court, there's no skin off the employee's back, because the employee can even be unrepresented in industrial court. You can go all the way. You don't need a lawyer. If you are belong to a union, you get your union rep to help you. There's the MTUC reps that help you. Employers too don't need lawyers involved, but they usually do get lawyers. So it's the employer that sometimes spends the most money having to go and defend all these things.
I see.
And the employer can never claim, let's say that the industrial court says, no, we find that the termination was lawful, it's fine, definitely a retrenchment situation. The employer still loses money by having had to defend it, whereas the employee doesn't get their job back, doesn't have to pay the employer anything anyway for bringing the employer to court, because the industrial court doesn't award costs. So it's fairly straightforward in that sense for the employee, and they don't have much to lose per se, but more to gain if they were unlawfully terminated. Yes. Yes, they do. And of course, they don't have jobs at the moment, so and it's difficult to get jobs. So of course, they are in a worse off position than the employer, who is still a company and maybe making profits, maybe not, who knows, until they disclose the accounts. The other thing though is that the industrial court now is really, really busy. And
not surprised.
So I recently had a case start in industrial court. It's at the very beginning stages, but the industrial court has fixed trial dates for August next year. So the employee sometimes has to wait a very long time before they see their grievances aired and their remedies given to them.
Can I, if I'm the employee my date is set for next year, can I look for a job another place right now? I can still be employed at another organization?
Yes, absolutely,
That makes a lot of sense. I can't be jobless until next year.
Okay,
so Aneera, thank you so much for your time today.
Thanks for having me, thank you.
So that is all for today's episode of The What Show. Don't forget to like and subscribe to our YouTube channel. Till our next episode, we'll see you soon. See you, bye.